Your name, your address, and your situation become public record the moment a lis pendens is filed on your property. Anyone can look it up, and within days, sometimes within hours, the calls start. The letters show up in the mailbox, and people even start knocking on your door. People are offering to save your home, they're offering cash for your property, and they're telling you to sign something right now before it's too late. This happens to homeowners over and over again. Someone is already stressed, already scared, already losing sleep. And then the phone starts ringing when people see a chance to make money because you're stressed out. Florida lawmakers saw this happening also, and they wrote a law to protect you. Today we are going to discuss that specific statute and show you the scams it's designed to stop. And also explain the tactic involving wholesalers that almost nobody talks about, but you absolutely need to understand before you make any decisions about your property. I'm Jim Armstrong, a licensed realtor with Momentum Realty. I'm a certified short sale and foreclosure resource, or otherwise known as an SFR. As an SFR, I'm focused on helping homeowners in financial trouble or facing foreclosure through short sales and other options. That's my everyday, along with the people that work on these files with me. Now, before we go any further, I need to say this up front. I'm not an attorney. I'm not going to tell you what's legal or what isn't. What I'm going to do is walk you through the statute in plain English and help you know what questions to ask. For anything beyond that, you need a Florida real estate attorney. I'll remind you of that again before we're done. And of all the things you need to know in your situation are your rights. Know your rights before you sign anything with anyone. I don't care who they are. I don't care how good it sounds. Know the law first. Then you can make your decisions. The law I'm talking about is Florida Statute 501.1377. Its official name is the Foreclosure, Rescue, Fraud, Prevention Act. We're going to review it in plain English so you can actually see it, understand it, and protect yourself. Before we get into the weeds, I want you to understand why the Florida Legislature wrote this law in the first place. Because the why matters here. When a homeowner falls behind on their mortgage and a lis pendens gets filed, that's the filing that goes in the official public record. And if you don't understand what a lis pendens is, check out my video that I just recently uploaded called What a Lis Pendens Actually Means. However, in short, it's a legal notice that tells the world there's a lawsuit pending on the property. Now here's the part that catches people off guard. There are companies, people, and operations that watch those filings every single day. They pull the list and they get your name, your address, and the details of the filing. And then they reach out to you. They have an offer. Sometimes it's a phone call. Sometimes it's a knock on your door. And look, let me be very clear here. Not everyone who contacts you is a bad actor. There are real professionals who work in this space. I'm one of them. But the Florida Legislature saw that when someone is about to lose their home, they're in a bad spot. And people in bad spots can be taken advantage of. So let's dive in. Florida Statute 501.1377 lays out specific things that are allowed and not allowed. Let's walk through them and see what they look like in real life. Because reading the law is one thing, but seeing the scam that's sitting in front of you, that's a whole nother thing. 1. No upfront fees. A foreclosure rescue consultant cannot charge or collect any money before the work is actually done. Not a retainer, not a processing fee, not a good faith deposit, nothing. The work gets done first. Anyone doing the work gets paid after they deliver on what they promised, not before. What this looks like in action? Well, someone calls you and says, we can help you save your home, but we need $2,500 to get started. That covers our filing fees, our startup costs. So you hand over the money and then you hear nothing. Or you hear a lot of excuses. Or the help that they promise, you find out you could have done that on your own by just making a phone call to your lender. Meanwhile, your money's gone and the clock is still ticking and has been the entire time. That's the kind of thing that this statute was written to stop. If that happens to you, talk to an attorney because they can tell you exactly where you stand. Number 2, no promises that I'll save your home. This one matters because it goes after an emotional pitch. If someone tells you they can stop the foreclosure, guaranteed you'll keep your house, or I'll make the whole problem go away. That's a red flag under Florida law. Here's why. What happens in a foreclosure depends on the lender. Your money situation, the property value, and the process that involves several other parties. No one person, no one company can guarantee a result in this situation. Anyone who tells you otherwise, they're not being honest with you, or they don't fully understand the process well enough to be handling your situation. When I work with a homeowner, I tell them the plain truth. Together we cover your options. We discuss the realistic market and the conditions in relation to your situation. I don't promise anything, especially things I can't control. And neither should anyone else. Number 3, no taking title to your property. This is a big one, and this is where people get hurt really badly. Some of these operations work by talking the homeowner into signing over the deed. They tell him it's temporary. They say, it's to protect you. Yeah, it's just while we work out this deal. They say they'll give it back once everything is sorted out. Under Florida law, a foreclosure rescue consultant cannot take title to your home as part of the rescue deal. That is legal title or even equitable interest. Doesn't matter. If someone asks you to sign over the deed, that should end the conversation. Walk away. No, safely run away. I'll say that again because it matters. If anyone, for any reason, while claiming to help you with your foreclosure, asks you to transfer your title or sign over the deed to them, stop. Leave the room. Call an attorney. This is exactly the kind of deal this statute was written to prevent. No sale or leaseback schemes. This is a sneaky one because on the surface, it sounds like a really good deal. Here's how it works. Someone offers to buy your house. They tell you that after the sale, you can stay in the home as a renter. You keep living there. The foreclosure just goes away, right? Sounds good? In practice, here's what really happens. The new owner now controls the property. Your equity is gone. You're now a tenant, not the homeowner any longer. You have no ownership rights. And you're one missed rent payment from getting evicted on top of everything else that you've been dealing with. The statute blocks this in the context of foreclosure rescue because it takes the homeowner's equity away while pretending to help them out. You think you're saved, but what actually happened is you lost your house and became a renter in it. Number 5, everything has to be in writing. If someone is going to provide you foreclosure rescue services, the deal has to be in writing and in detail. The law says the written agreement must include the exact services they're going to provide, the total cost, the terms of payment, and notice of your right to cancel. Here's the thing. The agreement has to be in at least 12-point uppercase type. The legislature did want you to get buried in the fine print. They wanted you to be able to read it. If someone gives you a contract to sign and it's dense, small, hard to follow, or missing any of those required items, that's a problem. Number 6, you get 3 days to cancel. This one is about the agreement itself, not the money. The money is covered in number 1. After you sign a foreclosure rescue agreement, you have 3 business days to cancel the deal. Walk away, tear it up. No questions asked, no penalty, no cost. You just say, I changed my mind. Done. Now, if you did pay money, which you shouldn't have because of number 1, this is the part of the statute that says that they have to give it back within 10 days after the cancellation. This is your cooling off period. The legislature put it in there because they knew people in trouble make decisions under pressure that they wouldn't have made otherwise. 3 days gives you time to think, talk to someone you trust, and talk to an attorney to read the contract again with fresh eyes. If anyone tells you this deal has to happen today, right now, no cooling off period, that should raise some serious questions in your mind. Real professionals know this law exists. Real professionals respect the 3-day window. If someone is trying to rush you past it, that tells you everything you need to know. This is the part that doesn't get talked about enough. And I want to spend some time on this because this is where the real damage can be done to homeowners in foreclosure. So please stay with me here. After a list pendens is filed, you might get a call or a letter from someone offering to buy your house for cash. Fast close. No banks involved. No hassle. When you're stressed and you're watching the calendar, that sounds like the answer to your problem. But here's what can happen with a lot of those situations. The person making the offer has no plans to buy your property. They're a wholesaler. And I want to be clear. Wholesaling itself is a legitimate real estate strategy. It's legal. It exists in the market, but the way it works matters. especially when the homeowner is looking at a foreclosure. Here's how the wholesaler's business works. They put your property under contract at a price that's typically below market value. Then they take that contract and they sell it or assign it to another buyer for a fee. That fee's their profit. They were never planning to close on your house themselves. They were planning to just flip the paper. Now, when this happens in a normal market to a homeowner who isn't in trouble and who understands the deal, that's between those two parties involved. But when a homeowner is in active foreclosure, everything changes. And here's why. You're on a timeline. The foreclosure process has deadlines. Your lender has deadlines. The court system has deadlines. Every week that passes is a week that you can't get back. So the wholesaler puts you under contract. You think you've got a deal. You might stop looking at other options. Maybe turn away a real short sale conversation because you think the cash deal is going to close. Weeks go by, maybe a month, maybe two. And then the wholesaler can't find someone to assign the contract to, and the deal just falls apart. They just walk away. There's no consequences for them, and they just move on to the next property. You don't get to walk away. You're still in the same house and still in the same foreclosure, except now you lost time you didn't have. And in a foreclosure timeline, that time loss could be the difference between getting a short sale approved by your lender and watching your home go to auction. It's about the time. And time is the one thing a homeowner in foreclosure doesn't have enough of. Now, there's two more things that you need to know about, and I'm going to explain them separately because they're different issues, but both of them matter. The first is the arm's length requirement, and if you're pursuing a short sale, your lender has to approve the contract. And lenders, including the big ones backed by Fannie Mae and Freddie Mac, require what's called an arm's length transaction. So, if a wholesaler puts your property under contract with assignment language and you're trying to get a short sale approved, you need to ask yourself whether that contract is going to meet your lender's arm length requirement. From my experience, working these files, that's a question worth asking before you sign anything. The second is short sale flipping. This is separate from the arm's length issue. The SFR certification program from the National Association of Realtors lists short sale flipping as a form of short sale fraud. That's not my opinion. That's straight from Freddie Mac's own fraud investigation unit, quoted in the SFR training materials. Short sale flipping is when somebody buys a property through a short sale at a low price and then quickly resells it for the profit. Freddie Mac flags that as fraud because it usually involves some kind of manipulation to get the lender to accept a lower price than they should. That's why Fannie Mae and Freddie Mac put deed restrictions on short sale properties. They block reselling the property within 30 days at any price. And then they block selling it for more than 120% of the short sale price within 31 to 90 days. Those restrictions exist to prevent exactly this. So, when a wholesaler approaches a homeowner in foreclosure with a below market offer and plans to assign that contract to someone else for a profit, you can see how those issues start to come into play. Either way, if you're facing foreclosure and somebody shows up with a cash offer, the right questions you need to ask: do they have proof of funds? Meaning, do they have the actual money to close, or are they planning to sign the contract? Are they the end buyer, or is there assignment language in the contract? What happens if they don't close? What's your backup plan? How much time will this take off the clock? Those questions will tell you whether you're dealing with a real buyer or someone who's using your situation to make a fee. Here's a list of warning signs. If you see any of these, I want you to stop what you're doing and talk to an attorney before you move further anymore. An unsolicited contract right after a list pendens is filed. They found you because your filing is public record. That in and of itself is not illegal, but it should make you ask right away, how did they get my name and what do they want? And who are they? A real professional will answer those questions straight up. A scammer will dodge or pressure you to keep talking to deflect. Your situation is serious. I won't pretend it isn't. But a real professional will give you time to think, time to get advice, and time to read whatever you're asking them to sign. If someone is rushing you, ask yourself why. Promises that sound too good to be true. If someone is making those guarantees, they're either misleading you or they don't understand the process. You just heard what the law says about that. If they ask for money first, the answer should be no. Anyone ask you to sign over the deed or the title? I said it before and I'll say it again. If someone asks you to transfer your title, stop, leave, call an attorney. That's the deal this entire law was built to prevent. Cash offers was assignment language and no proof of funds. Read the contract. If it says and/or assigns next to the buyer's name, or if there's a clause allowing the buyer to assign the contract to another party, that's a wholesaler. And in a foreclosure situation, especially if you're heading towards a short sale, the contract is going to raise questions with your lender. Ask for proof of funds. If they can't provide it, you have your answer. Now, I want to take a few moments to explain how what I do is completely different from everything I just described, because I think the contrast matters. I think it helps you see the difference between someone working inside the rules and someone trying to work around them. When a homeowner comes to me with a distressed property situation, here's what I do. First, we sit down and I look at the numbers. What do you owe? What is the property worth in today's market? What's your money situation? What's the timeline, etc. I'm honest with you about the things and where you stand. If a short sale makes sense, I'm going to tell you it makes sense. If it doesn't, I'm going to tell you that also. I'm not going to pitch you on something that isn't right for your situation. Now, I'm going to walk you through a simplified version of how a short sale actually works. Every situation is different, and every file takes its own path to get to a result. But in general, here's what happens. I list your property through normal real estate channels, and just like any other listing, a buyer comes in and makes an offer. That offer, along with your hardship paperwork, goes to the lender for review. The lender's loss mitigation department looks at everything: the offer price, the property value, your hardship, the numbers. They either approve the short sale, come back with a different number, or we go back and forth until we get to a place that works. My partners and I, we handle the lender side. I also manage the listing and all the other real estate details. There's a lot more to it than that, and no two files look the same, but that's the basic idea. Here's what I don't do. I don't charge you anything up front. The bank pays my compensation at closing. You, the homeowner, don't owe me a single dime. I don't take title to your property, and I don't ask you to sign over the deed. And I don't promise to save your home. I can't guarantee what your lender will decide. Nobody can. What I can do is work the process, put the file together the right way, present it to the lender the right way, and give you the best shot at an approval that lets you sell, avoid a foreclosure judgment on your record, and move forward with your life. That's standard real estate practice. It's an arm's length transaction. The bank approves the sale. The bank pays the compensation. The homeowner walks away without a foreclosure on their credit. It's the opposite of what the less scrupulous actors are doing. And the law I just spent the last few minutes walking you through, it exists to protect you from the people who aren't doing it the right way. If you received a list pendens, or you know you're falling behind on your mortgage, or you already have been contacted by someone and you're not sure about what they're offering you, here's what I'd tell you. Talk to someone before you sign anything with anyone. Not after. Before. Get your questions answered. Understand what you're looking at, and make your decision based on information, not pressure. You don't have to air this out in public. The comment section below isn't where this conversation belongs. Reach out to me directly. Email me at jimarmstrong904@gmail.com or book a time on my calendar. I'll put the link in the description of this video. The conversation is free, it's private, and there's no pressure. I'd rather you call me and find out a short sale isn't the right move than to not call me and lose time that you can't get back. If you're a real estate agent and you've got a client who's heading into trouble, or you're not sure what to do, reach out the same way. I handle the lender side, the paperwork, and the processing. I have a referral structure that makes it worth your time. If this video helps you understand something you didn't know before, share it with someone who might need it. That's how this information gets to the people it's meant for. One last thing, and this is important. Like I said at the top, I'm not an attorney and I'm not a CPA. Nothing in this video is legal advice. I walked you through what the law says in plain language, but I'm not your lawyer and I can't tell you what to do about your specific situation. If someone has already asked you to sign something, or you already entered into a deal that you're not sure about, talk to a Florida real estate attorney. They can look at the details and tell you where you stand and advise you on your next step in a way that I legally cannot do. Again, the statute number is Florida Statute 501.1377. That's the Foreclosure, Rescue, Fraud, Prevention Act. Thanks for watching. I'll see you next time.